Some Reflections on the Reading of Statutes. Felix Frankfurter, Columbia Law Review, 1947. It's not unusual for a judge to hear a case concerning a law or statute that's ambiguously worded or highly complex. They still need to make a ruling, so how should they figure out what the statute actually means? In 1947, Supreme Court Justice Felix Frankfurter tackled this fundamental challenge in his article, Some Reflections on the Reading of Statutes. The problem, as Frankfurter saw it, starts with the nature of words themselves. Anything that is written may present a problem of meaning, he explained, and that is the essence of the business of judges in construing legislation. Unlike mathematical symbols with their precise definitions, the language in laws, especially complex ones, rarely achieves more than approximate precision. Even seemingly straightforward phrases can become puzzling when applied to real-world situations. So how should judges approach this task? Frankfurter outlined 3 essential tools. First, examine the actual text of the law. Second, understand the broader purpose that Congress was trying to achieve. And third, consider the historical context in which the law was written. To show how these tools work in practice, Frankfurter pointed to 3 judicial masters of statutory interpretation. Justice Holmes had what Frankfurter called a sure-footed sense of words and the feel for their fittest use. Holmes would carefully dissect the language of a statute while considering how similar words had been used throughout legal history. Justice Brandeis took a more scientific approach, diving deep into legislative records and committee reports. He would exhaustively research not just what Congress said about a law, but also the social and economic problems they were trying to solve. Justice Cardozo developed yet another method, demonstrating how to balance a law's literal meaning with its broader purpose. He insisted that words must be read within their setting and framework, showing how a statute's language, purpose, and historical context all work together. But Frankfurter recognized that even with these tools, judges still have considerable room for interpretation. Laws aren't abstract propositions. They're expressions of policy arising out of specific situations and addressed to the attainment of particular ends. The challenge, as he saw it, is that legislative ideas are both explicit and inherent. The crucial question becomes, what is below the surface of the words and yet fairly a part of them? Frankfurter didn't offer any easy solutions. Instead, he reminded judges that in our democratic system, their job is to interpret laws, not make them. He wrote, "Fit legislation and fair adjudication are attainable. The ultimate reliance of society for the proper fulfillment of both these august functions is to entrust them only to those who are equal to their demands." In short, he concluded Congress should focus on making appropriately specific laws, and judges should balance careful analysis with appropriate restraint.